So hello friends, I am extremely sorry that I could not upload the video of the newspaper analysis of 3rd August because of some personal reasons. So today I am doing it, and on 4th August I will do it tomorrow. And as far as the 3rd August newspaper is concerned, there was an article by Manmohan Singh on economic situation, but again I find it is too general. Then there was an article on education policy, so this will keep on evolving and someday we will discuss that in detail. From the 3rd August, I found only one article relevant for discussion, the article in Hindu by Faizan Mustafa with respect to the Char Dham verdict. Now, what I feel that what verdict came, what is there in the act is not so important. What is the verdict or what is the act is not so important. We have to understand the issue in a very holistic manner. Today interestingly, on 4th, there are 2-3 articles on Article 370, one of my favorite topic in Indian polity and international relations. So I promise that I will give you a holistic idea on that particular topic. Regarding the newspaper analysis, my suggestion is it is not necessary that you go through all the articles without developing that capacity to touch the soul of the article and the crux of the article. Don't do anything for the sake of doing it. Be very selective. It's not that every day, every facts, figures have to be noted. So, you should understand these articles conceptually, because articles in themselves are not enough. You have to understand the concepts involved, the issues involved in that article. So, how do I look at pen? Excuse me, just yeah. So the first thing is, how do I look at the entire issue? ये एग्जिट कहाँ से होगा मनु? Note 5. Yeah. So the article which I am referring is an article by Faizan Mustafa, and this article is on Char Dham verdict. Okay, so there is an art of understanding the newspaper's articles in context of our exam, and how should we look at this particular article. So I will look this particular article from the wider angle, and the wider angle that I can find in this article is the nature of Indian secularism. So somehow the broad context in which this article has to be understood, the nature of Indian secularism, and we have to understand the articles 25, 26 and 28, but primarily 25 and 28. Now we see that since last 2-3 years, the state intervention in the temple administration, in the religious practices, has become a matter, and we have seen the Sabrimala verdict, we have seen Padmanabha Swami verdict, and now this verdict related to Char Dham. Fine. So that article I will see in context of Indian secularism and its complexities. This is the first thing we have to understand. What is the typical nature of Indian secularism? Then we have to understand what are the inner contradictions which give rise to the judicial intervention, inner contradictions in Article 25 and 28. And the third thing is we have to understand the issue of state intervention in the temple administration. Fine. So, what is the peculiar nature of Indian secularism, in whose context we can understand the state's intervention in the religion, and not just in the management of the religion, but also in the practices of the religion. Okay, so regarding Indian secularism, we can say that Indian secularism is a painfully, I am using this word, painfully elusive in nature. What exactly is the nature of Indian secularism remains somehow elusive. And at times, the question comes in the mind of the people that how India is a secular state when a state goes for intervention in the religious affairs. So, one general question which often comes to the mind is how India is a secular state when states intervention in the religious matters is constitutionally sanctioned. This is the question that I see in this particular article, how India as a secular state, when states intervention in the religious matters is constitutionally sanctioned. Means the Constitution of India itself allows states intervention in the religious matters. For example, if we take Article 25, right to religion, Article 25, Clause 2 and Article 25, Clause 2A and 2B. So, Constitution itself permits. Article 25, Clause 2A says that a state can intervene in the secular activities related to any religion, and second, it also specifically says that a state can intervene in Hindu religious institutions for the sake of reform. So, the puzzle becomes all the more difficult to solve when Constitution itself says, point number 1, is state to intervene in the religious affairs, and the second thing is state to intervene in religious affairs means in India there is no strict separation between religion and state. Fine. So, Article 25, Clause 2A. Article 25, Clause 2B. It says, a state will intervene in Hindu religious institutions. Means, a state will not intervene in Muslim religious institutions or Christian or Parsi religious institutions, but a state will intervene in Hindu religious institutions. So this shows that our constitution also does not follow the equidistance model or the equal treatment of all religions. Fine. So now we have to understand what is secularism. Or what is actually a secular state. Fine. So as you know that by 42nd Amendment Act 1976, it was explicitly mentioned that India is a secular state. India was a secular state even before, but this word was not explicitly mentioned. So what exactly is a secular state? So you must be aware of that India has a colonial past, okay, and there has been a hegemony of the Western world even in academics. So basically the secular state which we generally assume is a Western concept. Okay, so the concept of secular state as it is generally understood is Western, and in Western countries we see two models. The first model is the separation between state and church. Now, as we see the Char Dham Act or many other acts, there is no separation in case of India. Second thing is, in the West, the model is equal treatment of all religions. Fine, but this principle is also not there in the sense in Article 25 Clause 2b you allow state's intervention only into the Hindu religious institutions. Fine. So basically when we will try to understand the secularism of Indian state by Western standards, it is bound to create confusions. So we have to understand that like Indian federalism, Indian secularism is also sui generis model. Means which originated in the India's unique circumstances. Fine. So, what were India's unique circumstances? The first was the practice of untouchability, and this was seen as religiously sanctioned, and this practice found in Hindus. The second thing was partition, and because of partition on the ground of religion, some minorities and the biggest minorities, the Muslims, remained in India, and they had the obvious sense of insecurity. Hence, for their proper integration with the country, there was a need to give the security to their culture, hence uniform civil code was not imposed, and the minorities, not just Muslims but other, they also had been given right to protect their language and culture under Article 3. Another example, we do not under Articles 29 and 30. Another example which shows that we do not follow the equidistance model. Now, untouchability was such a big issue, and it was not expected. When we know that even after so many years of independence, and we are living in a 21st century, the data show that untouchability is not abolished. So it was not expected in India that the civil society will itself come forward for the purpose of the reform, and hence the only institution which could be considered as modern, the only institution that could have brought the reforms was the state, and hence it was seen that there will not be a strict separation, rather a state will intervene in the religious institutions of the majority for the purpose of the social reforms. So in our system, church will not intervene in the state, but a state will intervene in the church. So that is why our model is called as principled distance model. So in Indian principled distance model, there are two features: no strict separation, and the second feature is no equal treatment. The treatment according to the exigency or the need. So instead of following any model, which would have been an ideal model in theory, but not an ideal model in Indian situation, or in not a model good in practice. So our constitution has gone for an innovative model of Indian secularism, which allows states intervention in the religious affairs, primarily for the purpose of either the social reforms or for the better management and administration. Okay, now keep these concepts in mind and let us understand the tensions and the contradictions between, within Article 25 and Article 26. Now, Article 25 is about the freedom of religion of individuals. Whereas Article 26 is the freedom to manage the religious affairs. And here this right is a right of religious denomination. Fine. So the freedom of religion under Article 25 is the freedom of individuals, and here it is a freedom to manage the religious affairs. Okay, so now Article 25, it gives freedom of religion along with freedom to practice, profess and propagate religion. However, this right in India is not an absolute right, and this is subjected to the other constitutional provisions, public order and morality. So this is not a complete or absolute right. However, the definition of morality, public order and other provisions of Part 3, so this puts a sort of restrictions on the enjoyment of the right. So freedom to practice religion, but at the same time this article also allows intervention in the secular matters. Now, which matter of the religion is to be treated as a secular matter and which matter of the religion is to be treated as a purely spiritual matter? This becomes a contradicting issue. So whether the management of the temples is a purely secular issue or whether the management of the temples is a secular domain or is it a spiritual issue. Now, in order to bring clarity Supreme Court has brought one doctrine known as essential practices. So the freedom, or what aspect of the religion is protected, that is the essential practices. But who defines essential practices? Judiciary. So the first case was the Shirur Mutt case, when Supreme Court gave this essential practices. Now this is one of the matter which is under consideration in Sabrimala case, because the point of conflict is that this activity is a spiritual activity, this activity is a religious activity. This is determined not by those who know the religion, rather than the judges who do not have any specific qualification with respect to the religion. So the gatekeepers or the supreme priest, judiciary itself becomes the supreme priest in this context. And we see that number of times judiciary has given the judgments which have certain far reaching and unintended and sometimes not so healthy consequences. So one such judgment is the Hindutva judgment, where judiciary has defined that Hindu is not a religion but it is a way of life. Okay, so now the next thing is Article 26, which gives the right to the religious denominations, but whether we belong to a particular religious denomination is or not, this is again to be determined by the judiciary. So things become very uncertain. Some, for example, Aurobindo Society is declared as a, Ram Krishna Mission is declared as a religious denomination. Aurobindo Society is not declared as a religious denomination. So again, religious denomination is to be determined not by the devotees or the followers or the believers, but by the judges themselves. And the article says they have freedom to manage their religious matters, and as far as their property and other matters are concerned, they will administer it according to law. Okay, so the Constitution itself provides a state to administer the property, to administer the secular affair. Constitution goes to the extent of making judiciary, like judiciary provides what is a spiritual aspect, what is a secular aspect, to what extent, and in secular aspect it allows a state's intervention. Similarly, whether I am a religious denomination or not, this is again to be provided by the judiciary. So that sometimes brings into the scrutiny, but scrutiny of Indian secularism. But again, we will have to see that India aims to emerge as a modern society. Modern society means as a rational society. Even when we look at God, we should look God not in a superstitious manner. We should look God in a rational manner. We are going for the rationalization of the religion. Certain religious practices which do not appear rational in the present context ought to go. The religion, its practices, this all has to be regulated in the wider interest of the public order and morality. And we have adopted the integrity and human dignity as one of the core principles in our preamble. So we cannot allow such type of religious practices which may be affront to the very fundamental principles of humanity, like human dignity. Number of times you must have heard about the concept or this doctrine that Indian constitution is a transformative constitution. So what is a transformative constitution? If you read Granville Austin, you will find that Austin says that Indian constitution is unique. Unique in the sense that it is a cornerstone of a nation. So in other countries, the constitution's purpose is to tell the powers and the functions of the government. But in India, the purpose of the constitution is to bring a silent revolution, to bring a social transformation. So our constitution is transformative constitution. The idea behind transformation is that unlike China, where revolution has happened, in India, through the constitutional and the peaceful means, we move from the traditional societies to modern society. We move from the superstitious society to a rational society. Even the citizens are expected to develop the scientific temper as a part of our fundamental duties. So Indian constitution is unique, India's history is unique, India's culture is unique, India's politics is unique, Indian circumstances are unique, and in this context you will have to understand the Indian secularism, and so you can also understand that why it is not against the idea of secular state if a state goes for making the regulations of the religious affairs as far as its secular matters are concerned in the interest of the wider public order, in the interest of the social reforms. Hence, there was no rational basis where the High Court would have declared the Char Dham Act as unconstitutional. There was no basis because it is in accordance to the words of the Constitution, means it is in accordance to the letter of the Constitution, it is in accordance to the spirit of the Constitution. Now, in this particular judgment, Supreme Court has also held that Hindu Dharma or the Sanatan Dharma, Hindu Dharma is not or the Sanatan Dharma is not a separate denomination. Almost all Hindus, they follow similar practices. So the details is not important. The essence of the entire position which judiciary has taken. Now, you can also say that the position which Supreme Court has taken in case of Padmanabh Swamy case is entirely different, because in Padmanabh Swamy case, the Supreme Court has you can say that Supreme Court has declared the order of a Kerala High Court as invalid, and Supreme Court has restored the right of the management of the temple with the royal family. Now, why even Padmanabha Swami temple judgment is correct? Because it has its own peculiar circumstances. We can never go for one size fit for all formula. It has its own history. It used to be managed by the royal family. In 1949, when the integration of the princely estate happened, that time also it was agreed that the royal family will be going for the management and the administration, and hence we have to see each case as unique and specific. However, despite so much litigation, we can say that still the many questions remain unresolved. Hence, we will have to wait for the review judgment of the Sabrimala. The 9-judge bench is going for the review of the judgment, and where in Sabrimala case the Supreme Court has declared that the practice of prohibiting a woman of a particular age is not permissible. So in that, the sole woman judge, Justice Indu Malhotra, had a difference of opinion, and she raised this point that we have to think the extent to which judiciary can intervene in the religious matters. More clarity will come when the judgment of Supreme Court will come with respect to the 7 issues mentioned in the review, which is under consideration by the 9-judge bench. So I can read out those issues. So to understand the entire debate in the right perspective, we have to understand the view of Justice Indu Malhotra in the Sabrimala case. What she said that, point number 1, the notions of rationality cannot be invoked in the matters of religion. Next, she said, what constitutes essential practice? Let religious community to decide and not the judges. Now, the 7 questions considered by the 9-judge bench, and once this verdict will come, only then we can have more clarity on these complexities. The first question is the interplay between Article 25, 26 and other rights in Part 3, especially Article 14. Then, what does the expression public order, morality, and public health means? Next, what is the constitutional morality in context of the word morality mentioned here? Then, extent to which courts can determine the essential practice. Then, the meaning of section of Hindus. Next, whether essential practices have constitutional protection under Article 26, and can people not belonging to that religion or to the particular religion can bring a PIL. So these are certain issues, and until unless these issues are not clarified, the entire issue will continue to remain quite elusive. Fine. So now I can show you these articles for greater clarity. Freedom of conscience, profession, practice. This is subjected to public order, morality, and health. Then there was no point to declare that act void, because a state can regulate the secular activities. So in India, there is no strict separation between religion and state. Next, the Constitution allows a state to intervene for the purpose of social reforms in Hindu religious institutions. And the next is freedom to manage the religious affairs. Again, this is also subjected to public order, and religious denomination has right to establish for religious and charitable purpose. They can manage their own affairs in the matter of religion and not in secular affairs. Own and acquire property. So if they acquire property, then they will have to give proper compensation and to administer property, but this is to be in accordance to the law. So now let us quickly see the article. Which we have been discussing. Sorry. So in this particular article, this is a sort of I will say it also contains a sort of prejudice or something like many things there is no need to say, but just you need to understand. I will leave all these articles here. So I don't find that there is anything which you can note it down from these articles, though the issue you need to understand. So basically, rather than this article, I will give you the list of certain cases which you can note it down, that will help you whenever you will write the answer. Okay. So I also took time to discuss this because I didn't want to just discuss what he has written and what is it. I wanted you should understand the issue in a holistic manner so that you can handle the questions. So the points which you can note it down is, the first case was the Shirur Mutt case. You can see in 1955. In this case, Madras Hindu Religious Community Endowments Act 1951 was challenged, but Supreme Court has upheld the validity. The significance of this act is the first act where Supreme Court gave the essential practices doctrine, and this was the first case, and this is the first act which allowed a state to establish control over the temples. Fine. Now the next case you can see, the next case in all the debates which you should know is Dargah Committee versus Sayyid Hussain Ali, 1961. In this case, Dargah Khwaja Sahib Act 1955 was challenged because state has taken away the right of administration from the khadims who were managing it. Fine. So Supreme Court has upheld the validity of the act, and it has been held that this act has an importance with respect to the interpretation of Article 26. So this act says that Article 26 only recognizes the right, it doesn't give the right. So Chishti were not the owners of that land they got in the Farman of the Raja of Udaipur. So only if they have right, that will be recognized, but this article does not give any right. So in your, whenever you read, look at this particular point. The next was Nath Dwara Act case 1959, known as Tilkayat Govindalji versus state of Rajasthan case, where court said, they said that the idols belong to us. So court said you own the idols, but the land belongs to the state. And then the this Char Dham verdict, by which a board will be constituted to look after the management and administration, including the administration of the property, and the members of the board will be nominated by the state government. And you must be knowing about Padmanabha Swamy case. So I hope that this discussion has helped you. Do read these cases. This will bring clarity. So let us meet tomorrow, and most probably I will touch up today's article on Kashmir. Thank you. Good night.